Good evening again, attorney, and good evening, classmates. Under Article 157 of the Revised Penal Code, the crime punishable is evasion of service of sentence. Under this article, the penalty of prison correctional in its medium and maximum period shall be imposed upon any convict who shall evade service of his sentence by escaping during the term of his imprisonment by reason of a final judgment. However, if such invasion or escape shall have taken place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, or floors, or by using picklocks, false keys, disguise, deceit, violence, or intimidation, or through connivance with other convicts or employees of the penal institution, the penalty shall be prison correctional in its maximum. Let us take note that the first sentence or the first sentence in this article refers to the elements that constitute the crimes of evasion of service of sentence, while the second sentence um, pertains to qualifying circumstances. The elements of Article 157 are the following. First, that the offender is a convict of final judgment. Second, that he is serving his sentence, which consists in deprivation of liberty, and that he evades the service of his sentence by escaping during the term of his sentence. And the first element, that the offender is a convict by final judgment. Let us take note that the judgment in criminal case becomes final after the lapse of the period for perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or the defendant has expressly waived in writing his right to appeal. Instances where there were no final judgment yet are the following. First, instance where the convict escaped within 15 days from the promulgation or notice of the judgment without commencing to serve the sentence, or without expressly waiving in writing his right to appeal. In this case, there was no final judgment yet. Detention prisoners and minor delinquents who escape from confinement, because detention prisoners are not convicts by final judgment, since they are only detained pending the investigation or the trial of the case against them. Minor delinquent confined in the reformatory institution are not convicts because the sentence is suspended, and if the accused escaped while the sentence of conviction was under appeal. Under the second element, that he is serving his sentence, which consists in deprivation of liberty. Deprivation of liberty means taking someone's freedom away. A recent Supreme Court judgment decided that someone is deprived of their liberty, if they are both under continuous supervision and control and not free to live. Deprivation of liberty also includes destierro. In the third element, that he evades the service of his sentence by escaping during the term of his sentence. It should be by escaping during the term of his sentence, which consists in deprivation of liberty. So when someone is deprived of his liberty because of his pending case, because he was uh, convicted of a crime, and then he escaped during the term of his sentence, he is liable under this article. The term escape, take note, has been defined as to flee to avoid arrest. Qualifying circumstances under Article 157 are those in the second paragraph: by means of unlawful entry, breaking doors, windows, gates, walls, roofs, or floors, by using picklocks, false keys, disguise, deceit, violence, or intimidation, or through connivance with other convicts or employees of the penal institution. In the case of People of the Philippines versus Florentino Abellon, GR number L-1960, decided on November 26, 1948 by Justice Montemayor, the issue is whether or not evading a sentence of distero was punishable under evasion of service of sentence. The facts of the case are as follows. The municipal court found Florentino Abellon guilty of attempted robbery. Abellon was sentenced and ordered to serve 2 years, 4 months, and 1 day of destierro, during which he should not enter any place within the radius of 100 kilometers from the city of Manila. On September 17, 1947, Abellon went beyond the limits made against him and commit vagrancy. Upon arraignment, he pleaded guilty and was sentenced 2 years, 4 months, and 1 day of prison correctional with the accessory penalty of the law and to pay the cost. The counsel of the appellant, the counsel of Abellon, contended that Abellon, evading a sentence of destierro, was not criminally liable under the provision of Revised Penal Code Article 157 for the reason that Article 157 referred only to persons who were imprisoned in a penal institution and completely deprived of their liberty. The counsel based his contention on the word imprisonment used in the English text of Article 157. Again, the issue is whether or not evading a sentence of destierro was punishable under evasion of service. The ruling of the court is yes, and let us take a look again at the elements. First, that the offender is a convict by final judgment. In this case, we will know later that he is serving his sentence, which consists in deprivation of liberty. It was said that destierro is a deprivation of liberty, that he evades the service of his sentence by escaping during the term of his sentence. In this case, Abellon went beyond the limits that is allowed by him and commit vagrancy. The court ruled inasmuch as penal code was originally approved and enacted in Spanish, the Spanish text governed. It was clear that the word imprisonment used in English text was wrong or erroneous translation of the phrase sufriendo privación de libertad used in the Spanish text of the Article 157. The court ruled that it was clear that a person under sentence of destierro is suffering deprivation of liberty and escapes from the restriction of the penalty when he enters the prohibited area. Although the Solicitor General impliedly admitted destierro as not constituting imprisonment, it is a deprivation of liberty, though partial in the sense that, as in the present case, the appellant by his sentence of destierro was deprived of the liberty to enter the city of Manila. Hence, Abellon was guilty of evasion of service of sentence under Article 157 of the Revised Penal Code. Thank you.